Okay, let's start with the call of the case. This is the case of Garland Feverito et al. Versus Fulton County et al. Civil Action 2020 CB 343938. Let's see who we have here. Do we have Todd Harding?
Okay, you're on.
Do we have Paul Coons?
No.
I don't see Mr. Cheeley. It's my understanding he has a conflict.
Hey, please support, Your Honor, Mr. Cheeley is in a jury trial. I control under and co-counsel Mr. Cheeley, and I will be addressing the arguments today in the court for Mr. President Halbert's office. For Commissioners Jeffords and Sept.
Okay, welcome.
Thank you.
Mr. Bundren, Mr. Halliburton. I also have a note that we have a Gabrielle Holland. Is Ms. Holland here?
She's not going to make it this morning.
All right. Mr. Samuel is here.
Good morning, Your Honor.
And you're representing Mr. Johnson, Alex Wan, and Bernetta Neridan.
That's correct.
All right.
Well, Amanda Clark Palmer here.
Okay. Welcome, Ms. Palmer. Do we have Mr. Joyner with us, David Joyner? Mr. Joyner online.
It's my understanding, Your Honor, he was going online.
Okay. Mr. Joyner, are you with us? If so, would you please enable your video and your audio? No response. Now, Mr. Joyner represents Mr. Wingate and Ms. Ruth. And so he's an important person. Does anyone have any idea where he is right now? We have Mr. Rosenberg here representing Morgan County. Welcome. And Ms. Ringer? Okay, welcome. We have, I see that Mr. Lohman is with us remotely. Is that correct? All right, welcome. We have Ms. Burwell, who's representing the clerk this morning.
Good morning, Your Honor. Everybody's not the clerk, and I'm here with my colleague from.
Good morning, welcome.
Yeah.
Okay, we also have Mr. Joyner. Can you hear me?
Yes, Your Honor.
Okay, good.
Good morning.
Good morning, and you're representing Mark Wingate and Kathleen Ruth.
That's correct, Your Honor.
Okay, do we have, and Charlie McGowan has been attending these hearings in the past, even though she doesn't officially represent anyone, even though the Secretary of State hasn't actually intervened. And so do we have Ms. McGowan?
Yes, Your Honor, I'm on virtually, and I just intend to observe this morning.
Oh, all right, perfect, thank you. Okay, we have a number of motions that have been filed and that are ripe for hearing today. The first one to be addressed is the respondent's motion to dismiss. Are you ready?
We are. John, I yesterday filed a response to a meeting that was filed on Friday. You get a copy of
I have a copy. I read it this morning.
This is the response to a different motion, I think.
This is the one that I have that I read this morning is a response of Neridan, Wan, and Johnson petitioner's motion to dismiss without prejudice. Is that the one that you're referring to?
Hey.
Okay, I have that here in front of me and I've read it. And I'm ready to hear your argument as it relates to the motion to dismiss.
Your Honor, the motion to dismiss that we filed was filed on August 12th of this year in response to both new complaints that were filed following the June 21st order, where you dismissed all the entities, the county, and I call it BRE, the Verification of Elections, the clerk's office. In response to that, well, it's actually the same time that you entered that order, you also permitted the petitioners to add 5 new individual, that is, in their individual capacity, there are 5 members of the BRE. I emphasize in their individual capacity, not in their official capacity. Ms. Palmer and I represent Ms. Nervin, Mr. Wan, and Mr. Johnson. As you know from our pleadings and probably from the press as well, Alex Wan was not a member of the board in November of 2020, had nothing to do with the election, had nothing to do with the recount, had nothing to do with the risk limiting audits, had nothing to do with anything, frankly, the 2020 election cycle. He came on the board in March, I think, when Mary Carol Cooney became ill and had to leave the board. So we raised that in our motion to dismiss. I'm just trying to introduce the people to you to ask you who they are. Since we filed the motion, Alex Wan has left the board. He is now voluntarily retired, resigned, whatever. So he'll have nothing to do with future elections.
Right.
So we have, discussed with you in our motion to dismiss the complaint as to him, that it be, summarily granted with regard to him. Renetta Nureddin was on the board in the fall of 2020, November 2020, and during the recounts and during the risk limited audit. But her term on the board concluded at the end of June. That was the end of her tenure, and she was replaced and is no longer on the board. So, as we point out in our motion, we couldn't realistically grant injunctive or declaratory relief as to her. Aaron Johnson is the only one who was, is, and will be on the board for all the relevant time periods. In our motion to dismiss that we filed on August 12th, we raised a number of issues, some of which you've heard before. We raised a standing issue, and the standing issue was first brought to your attention in the answer to the first complaint back in the complaint was filed in December, the answer was filed in January this year, and it was listed as an affirmative defense that the plaintiff lacked standing to assert this cause of action. Having been raised as an affirmative defense, we thought it was now time to bring it to the court's attention to rule in connection with the motion to dismiss. The second basis for our motion to dismiss, and I'll elaborate on each of these if you want me to, or answer any questions, is the impropriety of the cause of action. We phrase that causes of action that they assert for both declaratory relief and injunctive relief. We have previously briefed for you prior to the last hearing on virtually all the issues relating to the declaratory judgment. In fact, in all honesty, I really just kind of cut and pasted the arguments that we raised prior to the June hearing, why declaratory judgment cannot be granted in this case. And simply reasserted them here because you never ruled on that. For good reasons. You dismissed all the then existing parties, so there was nothing pending. There was no, I don't know who you'd be granting the motion to dismiss with regard to. We had suddenly all new parties who had not yet filed an appearance. But now it's right. And I don't think anybody can contest the fact that now is the time to rule on the motion to dismiss with regard to the declaratory judgment.
And perhaps the new parties might not have raised those issues. Who's to say? And perhaps the new parties may not have raised those issues.
That's why you didn't do it the first time. That's exactly right. We actually addressed it very briefly in our oral argument. We talked about the fact that you can't rule on motions that have not been filed with regard to parties who are not able for it. We represent 3 parties, the 3, you might call it as it is, the 3 Democrats on the board for what it's worth. So we are insisting that the declaratory judgment be dismissed. The cause of action for declaratory judgment be dismissed for a variety of reasons, most of which are just absolutely plain and simple and based on the law that the petitioners don't even contest. That there has to be a relationship between the parties. There has to be either a contract or a statute or an agreement that one party says is enforceable or needs to be interpreted. And there's a problem with the future. There's a problem in the future that the parties don't know which way to go, or at least one of them doesn't know which way to go. Well, the court says the light needs to be shown on it. None of that exists in this case. So we raised that. We've also raised in our motion to dismiss it's kind of a preemption argument. It's the argument that there are a number of statutory bases for challenging an election, for challenging the count, for challenging the audit, challenging the integrity, if you will, of the VRE. And the petitioners have adjured all of those. They have taken none of the steps needed to accomplish what they in fact want to accomplish, which is to question the validity of the 2020 election. They will tell you, and I'm sure I'll hear a lot about it now, this is not an election challenge, but they are still challenging the integrity of the election, and there are procedures in place to do that, none of which they have availed themselves of. Now there's, of course, a new law that grants to the state legislature and to the state election board the authority to do that, and asking you to interfere with that process. You will be interfering with it, allowing them to do their own personal audit and their own personal. You look like you're about to ask me questions.
I have many, but
Yeah,
I want to hear. You might, your argument might get me to the point where I don't have any left. So let's just let you finish, and then we'll go from there.
But right now I'm just doing a table of contents, so I'm going to go back and talk about some of these issues in greater depth. But I prefer to address what you want to address. But let me just kind of talk about standing first. That really hasn't been addressed previously. And we clearly have differences of opinion with the petitioner with regard to standing. The law in Georgia is no different than the law in federal court. There's no light between the two different theories of standing. In fact, the state cases cite the federal standard. Fulton, Sept, and all the cases talk about standing to raise a constitutional challenge. They don't cite any distinction between what is the federal law standing and what is the state law standing. There can be differences. The United States Supreme Court revealed this past term in the TransUnion case. A state can establish different rules of standing. They can if they want to. It's not necessarily a constitutional rule. But in Georgia, there is not a distinction. Georgia has basically adopted all the federal jurisprudence of standing, and in particular in connection with this type of case. Here's the problem with standing, as we kind of tried to more clearly define in our reply brief, not the original brief, but the reply brief, because they the petitioners 20, 25, 30 pages talking about the standing. Perhaps reflects their concern with that. When it comes to an election dispute, however you want to call it, election challenge, or anything challenging the constitutionality of election procedures, all the cases that they cite, and every case that I found, including Curling, including all the recent cases in Georgia and all the cases that were spawned by the 2020 election, they tend to fit into one of four big buckets, silos. One is where an actual party is challenging the election. Bush v. Gore, quintessential example of a contested challenge. I've got standing. I'm running for election. I've been cheated. My votes aren't being counted. Something's wrong. I deserve to win. I have standing. Nobody questions that. So if Mr. Trump wants to come and challenge the election, I suppose he can. But it has to be a party.
That's not what we're doing here.
Clearly. I'm just going to identify the buckets and then show that we don't belong in any of them. The second one is where there's a state statute that specifically says, Judge Amaro, you can't vote. You got to pay money to vote. You got to take a educational test before we're going to let you vote. You can't vote in You can make up any silly example you want. Where there's a state statute that specifically addresses your ability or right to vote or the method by which your vote will be handled. No doubt about it, that has standing. And those are the classic cases, the one man, one vote, one person, one vote rule, all the famous cases, some of them coming out of Georgia, Westbury, Alabama, Reynolds versus Sims. All those cases deal with your vote is not going to be permitted, or your vote, your vote is not going to count. They are not vote dilution cases, those cases. They are challenges to state statutes. And if I may, I'd like to take one little side trip here. There's a lot of relationship here. There's a lot of similarity in the arguments regarding standing and declaratory judgment. If you don't have standing, you can't get a declaratory judgment. If the declaratory judgment's prerequisites are not met, you'll see that standing doesn't work either. You don't have standing. So even in our brief, we had trouble with our library. We were kind of going back and forth, and it's hard to put headlines.
It's the issue of redressability.
That's right. That's exactly right. And so bucket number 2 is where you have a statute that's being challenged. Bucket number 3 is where you have curling, which is a little bit of a, I addressed.
That's what I want you to focus on at some point.
Sure.
Curling.
Yeah, curling was
Not exclusively, but at some point.
I'll do it right now. It's the bucket. We'll talk about
Okay.
that. Curling involves, find my copy.
This is Judge Totenberg
That's
talking about voting machines,
voting machines.
about cyber security, about hacking.
That's right. And Judge Totenberg addressed the standing issue in that case. And
She found standing to exist.
she found standing to exist, and the petitioners bring that to our attention, and I compliment them for doing that. It's an interesting case. Curling involves what I would analogize to be like a state statute. And here we look more to the declaratory judgment type case. There is no doubt about it in curling. That voting machine was going to be used to tabulate your vote. You, meaning the voters, the petitioner. There was no uncertainty about that. There was no uncertainty about the fact that what I'm challenging is going to impact you. Okay? That's what Judge Totenberg said. She said the voting machines that are being used here are unsafe, they are hackable, that's the right word. There's dangers that will occur by use of these machines. It is not unlike the cases that challenge early voting hours, or conceivably even closing polling booths in certain neighborhoods. We're going to close, like in Texas, I think, we're going to close all the polling booths in minority neighborhoods, polling locations in minority. Those aren't state statutes, but there are rules or procedures that are being put in place. They will absolutely, positively, undeniably affect the next election. That doesn't exist in our case. There's nothing in our case, there's no allegation in our case, which is why curling doesn't govern our case. There's no allegation in our case that whatever allegations they're making will in fact occur in 2022. There's no certainty as to that. There's nothing imminent about that. There's nothing about counterfeit ballots. Who's going to get on the stand? Who's going to testify in support of a declaratory judgment action that it is positively going to occur that counterfeit ballots will be used in 2022 or 2024? Not a problem in curling. There's no doubt they were going to use those voting machines, those unsafe voting machines. That was a certainty in curling, just like the state statute, just like the regulations, just like the reapportionment case. There was nothing conjectural about it, as the cases say. There was nothing uncertain about this occurring. It was positively going to happen. That's why the other people have standing, and the people in this case, the petitioners in this case, do not. Because they are just simply saying, look back, look in the rearview mirror. Of course, we deny factually all of this, but look in the rearview mirror, and you'll see there was counterfeit ballots, there was double counting, there was, you name it. But nobody says it's positively true, undeniably true, that in 2022, the same things are going to occur. They couldn't possibly say that. Nobody can make that kind of prediction. That is a prediction that someone is going to commit a crime in the future. And we want you to issue a declaratory judgment action that you can't commit a crime in the future. Curling has nothing to do with that. Curling had nothing to do with identifying individuals who we are scared are incompetent, engaged in malfeasance, misfeasance, criminal conduct, ballot stuffing. None of that is true in curling. The other thing about curling is the voters were the people who were using those voting machines. Here we got people from Upson County, Wakefield County, Cobb County. With one or two out. The majority of the petitioners in this case don't even live in Fulton County. It has nothing to do with the procedures that are being in place. These are not laws that affect them in the sense of curling. They will say, oh, it affects us because the people of Fulton County, they get to vote 5 times. Because every time they vote, they're recounted 5 times. That's exactly what all the cases have said is a classic vote dilution that does not confer standing on anybody. That doesn't mean they can't be redressed. Right? And then that's exactly what the Lynn Wood's case said. We're not saying these problems are to be ignored. You just have to bring them in the right place. They say, well, you got to bring them in state court. That's why all those federal cases are irrelevant. That's not what Lynn Wood said. It would be the name of the case, not the name of the lawyer. What Lynn Wood said is, you've got to use the right procedure. And there's tons of procedures you can use if you want to claim that Fulton County had illegal voting procedures. You can do a recount. You can do an audit. You can file an election challenge. All those things that we talked about in our brief. Not one of which they did. Not one. That's exactly what William Pryor said. That's exactly what William Pryor said in the 11th Circuit decision. You got to use the right procedure. You're not remedying this. You have to use the procedure that's been designed to address the problem you are identifying in your case. So that's my response to Curl.
Doesn't Judge Totenberg distinguish Luan? Doesn't Judge Totenberg distinguish Luan in her analysis?
Why was the Supreme Court case? Yeah. Yeah, she does. And but again, the distinction.
Why does she do that?
I'm not trying to answer your question. What motivates the judge?
Well, can you read it? I mean, it's right there.
You got me with a page you're quoting from?
All right. On page 12, let's see, of my copy, that might not be helpful to you. She says, and I'll just read it. Here, the coalition plaintiffs are suffering injury from the voluntary exercise of their fundamental right to vote, not from just any sort of activity that they decide to engage in. In Clapper versus Amnesty International, USA, case site, the plaintiffs voluntarily spent money to take certain protective measures based on a hypothetical fear of being subject to surveillance. And in Luan versus Defenders of Wildlife, and there's the case site, the plaintiffs expressed an intent to voluntarily return to certain places they had visited before, which would deprive them of the opportunity to observe animals of an endangered species. These activities do not invoke the protection associated with exercising fundamental rights, such as the right to vote, which I believe in other places she describes as the beating heart of democracy.
No doubt about it.
So I guess what I'm wondering is why this doesn't fall into the bucket associated with the beating heart of democracy versus the bucket that is connected with being subject to surveillance and being concerned about an opportunity to observe animals of an endangered species.
Well, I don't mean to be overly repetitive, but the difference is, with regard to the certainty, right? There's no question in Curl you're going to be using a voting machine in some state. I mean, make it more extreme even than the facts that where it's hackable, it's subject.
Isn't the argument that they're making that there is rampant negligence, rampant mismanagement, ballot insecurity, a failure to vet independent contractors appropriately who are working on this important work? And as a result of that, they have created a precondition, the preconditions necessary for misfeasance to occur. For example, by actors with malintent who are designed and focused on inserting these sort of counterfeit ballots that could potentially dilute their votes. Isn't that the essence of their argument?
That sounds like it. Essence of the petitioner's argument. Yeah, very much like what Linwood claimed in Linwood versus Raffensperger.
Isn't the negligent environment a lot like a voting machine? Isn't the fact that you have alleged misfeasance by third-party contractors or individuals that have taken advantage of this condition a lot like malware that's being put into a voting machine that is thereby causing the petitioner's votes to be altered or diluted? Now, they're not talking about alteration here, but they are very clearly analogizing, I think, to what we're seeing in the Curling case. And so I want us to at least recognize where things are similar to a standing analysis where the United States District Court has found standing to exist. Now, there may be some differences, and I think you pointed out some of those differences, in particular on the question of redressability. I think that it's a little bit more concrete in the Curling case than perhaps it is here, and I'm interested to hear what they have to say about that, which also then goes to the question of whether or not an injunction can address those issues. But there is some really good reason to evaluate Curling in light of these facts.
I don't disagree with anything you just said, unless you're trying to imply or that you're asking us to infer that Curling controls the decision here. I don't think you did say that. And I emphasize again what I've said already, which is that Curling is in fact not talking about individual people engaged in malfeasance. They're talking about machines, which will absolutely, unequivocally, and I'm sorry to be repetitive, affect your vote. Your vote, not Whitfield County's vote, not Fannin County's vote, not all the people who are from different counties' votes, which is a standing problem.
How were the Curling petitioners impacted in a particular way by the potential for malware to be introduced into the voting machines?
How would they be?
How were they?
Well, there's public safety issues, there was privacy issues that Judge Totenberg addressed in that case, where Judge Totenberg said you're not going to have a private secret ballot, right? And people are going to be looking at your ballot, they're going to know who you voted for.
Potentially.
Well, but that's the essence of the machine. They're challenging the machine. The machine is, in our view, the analog to a reapportionment. It is a state statute, it is a state regulation, it is a state procedure, which is absolutely going to exist. Okay, which again, now we're drifting a little bit into the declaratory judgment argument, which is the same. It's the same issue. It's the likelihood of the dispute occurring or maturing or ripening. And there's no question these machines are being used. Maybe nobody will hack, maybe the hacking won't occur, but still the machines are invalid.
So if there were, in fact, counterfeit ballots introduced into the mix
in 2020,
and there is concern that that would happen again in the future if this issue was not redressed, which is the negligence in the office and the opportunity for misfeasance. And they're concerned that that could happen again, as they've alleged. And we have to assume that the facts set forth in the complaint are true for the purposes of this motion to dismiss. That in fact, there were some counterfeit ballots inserted into the mix. Is there any scenario under which, given this analysis, that these petitioners would have the ability to challenge what's happening by way of a suit in superior court asserting a violation of their state constitutional rights? Is there any scenario under which third parties with malintent who are diluting their vote can be challenged by them? Any at all?
Well, if the premise of your question, which it was, is that they have a concern, the answer is no. They do not have standing. The fact that they have a concern does not write them into standing to either get an injunction or to get a declaratory judgment action, judgment, because a declaratory judgment requires certainty.
If it's undisputed that their vote has been diluted by these bad actors who've inserted counterfeit ballots into the mix, they don't have any redressability through an assertion of a claim such as this. Is that correct?
As to the future, yes, that's correct. They got all kinds of remedies they could have used to address what they now claim with regard to 2020. Right? Got all these state statutes that enable you to challenge that. Got the GBI out there doing investigations. It's not like, as they would have it, I guess you can do this all you want, because Mr. Samuel says nobody cares. Untrue. If in fact there's counterfeit ballots being used, if in fact it's true that there are people intentionally counting, Mr. Trump's votes 10 times and Mr. Biden only once, or vice versa, obviously there's all kinds of things that can be done. You can't get either an injunction or a declaratory judgment action saying don't do that in 2024. I don't even know what you'd be declaring. Of course you can't do that. Of course you can't.
Has anybody looked at these ballots to determine whether or not there has been any counterfeit ballots introduced into the mix?
Well, until you entered an order that basically froze everything and said nobody could look at the ballots, the PBI was doing that and found no evidence of it.
Is there a report to that effect?
Even last time we were here, we were told by the AG who was here that the report is not done yet. We have talked to the people in the Secretary of State's office, the investigators there, and the GBI was in the process. They were questioning, in fact, one of the petitioners was actually the petitioner's witness, and not to get into what happened there. And she said, "Well, I thought it was these ballots. It turned out it wasn't those ballots."
So we're 8 months plus, right?
You stopped it though.
Did anybody make a request to intervene into this action to say, Judge, somehow or another, your injunction or has prevented us from being able to do anything? Is that part of the record in this case?
Well, you asked me a question.
Well, I'm asking you another question.
Yeah, I don't believe it's in the record in this case. We have addressed that issue it's also not in the record, with the Speaker of the House, Ralston, who asked us, can we bring in the GBI? And we said, that's fine with us, but you're going to have to do something with Judge Romero because he's not allowing anybody in there. Nobody's allowed to look at these ballots. We addressed it with Senator Rich Miller, who was the one who initiated the Performance Review Board, and said, the GBI has been doing an investigation, and the FBI is working with the GBI. They're all working on this, and it just came to an end. When the December lawsuit was filed, and in the spring, you enjoin anybody from looking at the ballots. And as we say, with all due respect, your order, in essence, said, now nobody else can do this. Nobody else can do an investigation, just these 9 people. they're the ones who, and maybe you didn't.
I don't recall the order saying anything to that effect at all. I'd be very curious to take a look at the language of the order. And to the extent that there are any other state actors that have an interest in doing this, you would think that the courthouse is open to them as well, and that they could do what they need to do in order to look at these ballots to determine whether or not there are counterfeit ballots in the mix. And it's really quite something to hear this argument. But in any event,
Well,
let's shift back to the legal issues.
yeah, and for what it's worth, Your Honor, I don't represent the GBI. I'm not in the Attorney General's office, and I don't know what their motive is for either challenging the order or asking you to allow the GBI to do an investigation or the FBI to do an investigation. I represent the GRE members individually, at this point, their individual capacity, who have no authority to, look at the ballots themselves.
I've not heard once in 8 months from any actor saying that they are somehow prevented from doing what they need to do in order to carry out their role to the taxpayers and to the voters. Go ahead, I'm sorry.
Well, I'm not sure where we are. I've made my standing argument.
Let's shift to the next one then.
Okay, well, then the declaratory judgment is similar. The declaratory judgment law that we cited and argued last time, at some length, and as I said, the issue here is very much the same as the issues raised before. And so I very much like the standing issue, which is what right do 9 people who are just saying we are concerned, the language was correct, we're fearful that our vote in the future won't count. That does not grant you declaratory judgment action any more than someone saying, I'm worried that the zoning board, as the example I used in my reply brief, that the zoning board is going to, once again, make a bad decision based on bad facts about how to rezone my neighborhood. There's nothing in the declaratory judgment action, the declaratory judgment act, which differentiates voting or any other procedure. They ought, in fact, there's a voting case in the site with getting a declaratory judgment action against the area. And the court said, you've got to be able to show the certainty of the problem arising. Not your concern, not your fear, but the certainty that the problem will arise and that it needs to be resolved ahead of time by the court. In that case, the petitioners aren't able to do that, and the court said, you don't have a declaratory judgment action standing. You don't have the prerequisites for a declaratory judgment. With regard to the injunction, we very briefly addressed that in this brief. Essentially, you can't enjoin illegal activity. That was actually raised by the Burwell last argument. You can't enjoin someone that said you can't use counterfeit ballots next year. It has no lawful effect only because obviously you can't. It's like telling someone, an injunction against murder. You can't enjoin criminal conduct. Criminal conduct is already illegal, so it doesn't require the imprimatur of the court. Injunction to somehow make it more emphatically illegal. We've raised the official immunity issue here. We believe that the complaint does not allege any facts to show that the allegations with regard to our three clients are ministerial acts. In their most recent brief, they claim that they are ministerial acts because all they have to do is follow the law. That's not the definition of a ministerial act. Ministerial act is not simply an act that is required by law and therefore is done by vote. These people are members of a board. They exercise discretion. They exercise their judgment every single minute in their official capacity. That's all they do is make major policy decisions about voting times, about voting locations, about all kinds of things that they have sat in many of their board meetings. Nothing is done by vote. Nothing is ministerial. It's all discretion. The very nature of what a board of directors is. The very nature of what this board is. And therefore, the higher standard to seek relief must be alleged and proven ultimately. These are not ministerial acts or simple negligence or reckless conduct is sufficient to overcome official immunity. If I could don't know if I have time here, reserve my time.
Take your time.
No, I don't have anything more to say. My opening remarks,
Okay.
but I'd like to answer any additional questions you have or respond to the, what the petitioners claim.
We'll hear from Mr. Bundren.
Hey, please, the court. This is a motion to dismiss proceeding, and the court is well aware of the standard of review and a motion to dismiss. The petitioners are not required to prove their case, they're not required to introduce evidence. The court knows that it cannot be granted unless there is with certainty under the confines of this complaint, no way when we get to trial, and no way when we produce evidence that we will be able or be entitled to relief under any set of provable facts. The respondents have got to establish in this motion to dismiss that we would not possibly be able to introduce any evidence within the framework of the complaint that would entitle us to any relief. That's a very high bar. The court's well aware of that. We have cited that in our brief and in our response. Essentially, what the respondents are arguing, and they did not file a motion to dismiss based upon a claim that the petitioners do not have an equal protection right or a due process right under the Florida Constitution, because clearly they do. They are not arguing that my clients don't have equal protection or don't have due process under the Constitution of Georgia. They did not even argue that there is no voting dilution claim under the Georgia Constitution, under equal protection or due process. They are assuming, as they must in this proceeding, that the equal protection rights and due process rights of the petitioners have been violated. And now they are arguing that this court does not have the ability to grant relief for what has happened and what is likely to happen in the future if the court does not grant the relief that we will be requesting at the conclusion of the evidence. We provided to the court throughout our brief arguments, statements of the law with respect to the voting dilution claim, the disenfranchisement claim, and the debasement claim. And I don't think that there is any dispute that if those facts are true and my client's rights have been violated by dilution, disenfranchisement, or debasement, we have a right to ask the court for relief for what occurred. And again, it's not our burden, it's the respondent's burden in a motion to dismiss proceeding. I agree with Mr. Samuel that the Georgia Supreme Court has interpreted the Equal Protection Clause and the Due Process Clause under the Georgia Constitution to be coextensive with what the United States Supreme Court has said, and the court agrees with that. And it's very clear, if we look at the cases, that a dilution, debasement, or disenfranchisement of a voter's vote by introducing counterfeit ballots, invalid ballots, by tabulating those ballots, by not having the guidelines to keep those ballots from getting into the tabulation, is a dilution because it takes away my client's voting franchise. The Equal Protection Clause, as the court's well aware, applies not just to the right to vote, but the right to have our vote counted equally, and to not have our vote diluted by allowing counterfeit ballots to be included in the tabulation. In fact, in our brief, Your Honor, we've cited case Reynolds versus Simmons versus Gore, in which the Supreme Court has very clearly said that the franchise or the right to vote, the essence of democracy, I think as the court indicated, is our right to vote, to have our vote counted, and to have it counted equally, and not to have it be diluted by including votes that should not be included. And that states have a fundamental obligation to ensure that that occurs. Our complaint has alleged in this case that that did occur in 2020, that counterfeit ballots were permitted, we have provided affidavits to the court in the petition, in the complaint, of people who saw during the recount ballots that they contended were and appeared to be then not valid ballots that were being counted. So we provided some evidence to the court, although it's not our burden at this point. It's the burden of the respondents to prove. There's no way with certainty that we'll ever be able to prove that. With respect to the standing issue, the court is correct that in Curley, in very similar circumstances, the Northern District of Georgia found their arguments to be unavailable. That's absolutely true. There is no real distinction. That was a case that involved the interference or not counting of the votes and the claims that were made in the Curley case, which we have outlined in our response. And the court there found they claimed the same exact arguments here. And the argument that they're trying to make is, which Curley rejected, is that if anybody else has an equal protection violation, or anybody else has a due process violation, that you as a plaintiff are not entitled, because there's others that may have the same violation. That was rejected by the court in Curley. Because she said this notion of this generalized grievance does not take away the fact that my client's rights have been violated by the dilution that occurred considering the complaint. We've also cited, in the case that the respondents rely upon principally is Wood versus Raffensperger.
Before you shift away from curling, what specifically is the redressability here? How, tell me the order that you're asking the court to enter at the conclusion of the case, should in fact you be able to prove the things that are contained within your petition.
We will be asking the court to enter an order that would enjoin the certain aspects of the policies and procedures by Fulton County that have shown to result in violation of equal protection and due process. Now, this is early on, so we don't know all of those things that occurred. We don't know how they all occurred, but we will ask the court to look at what occurred and to prohibit Fulton County and the board, the members of the board, from engaging in those similar conduct in the future with respect to future elections. Because if we look back and we say, well, that violated equal protection and due process because they allowed counterfeit ballots to be introduced, they counted the counterfeit ballots, they didn't have a policy or procedure in place, prohibit that from happening. It happened. We want to enjoin those kind of conduct and activities, enjoin policies, practices, and procedures in the future once the case is fully developed. But at this point, we don't know all of that because we're in a motion to dismiss procedure. We'll be asking the court to look at what occurred, to develop a remedy, which will be an injunction, to prohibit those things from occurring in future elections. In one case,
I'm sorry, please continue.
the one case that the respondents are relying upon is the Linwood case. And in that case, the 11th Circuit specifically said, and again, we have outlined in the brief that we have filed, Linwood was requesting extraordinary relief, as the 11th Circuit called it. Relief to prohibit the Secretary of State from certifying a presidential election. They outlined this extraordinary relief, and they outlined the fact that because of the nature of that extraordinary relief being brought in federal court under 42 U.S.C. 1983, that Mr. Wood did not have standing. But what they said is the type of relief, the type of issues Mr. Wood was addressing or attempting to address, which we aren't addressing here, like a voting dilution case or a malfeasance or negligence matter, is something that should be brought in state court.
They spoke about garden variety issues of vote counting and misconduct that may properly be filed in state courts.
That's correct. That's correct. We quoted that from the 11th Circuit opinion. That is exactly the type of case that we have here. But looking at this from a broader perspective, if my clients do not have a right to come to your court or to any superior court and to seek a remedy for their dilution of their vote under the Georgia Constitution. They're being denied a remedy in any place, at any location, at any time. And it allows the constitutional violation to go forward without being addressed.
I guess I really need to put a fine point on this. The question is, what is the particular injury that your clients have? Do we have to compare the injury that your clients have to the injury that is more generalizable, the one that is experienced by all of the voters in Georgia, and as Judge Pryor said in the 11th Circuit, every citizen of the United States, more broadly? I mean, how is this to be bounded, if not by particularity of injury?
The case law that we provided, I think the court is well aware that in a dilution case where you have diluted someone's vote, and my client's vote has been diluted, my client's votes have been diluted. That's our contention at this point in this motion to dismiss proceeding. They have been particularly injured because, given the allegations of our complaint to be true, that their particular vote has been debased, been disenfranchised, and it has been diluted. We are not required at this point to present all our evidence, but only that the complaint has been filed, complaint states what the dilution claim is, and that we have been injured by that. And we have no other place to go except at this point to seek remedy for that violation of the Constitution. The cases which the respondents have relied upon, the Parker case, which they relied upon, which was a bond case, doesn't apply here. It was a case that involved a bond statute with a criminal action, and it does not apply as a standard. Essentially, what the respondents are arguing in one of their arguments is that the Georgia legislature and the Georgia election code has preempted this court's ability to give relief to my clients when their equal protection and due process rights are violated under the Georgia Constitution. They have not cited a case that says that the Georgia election code and the legislature has the ability to preempt the provisions of the Georgia Constitution. But that's their argument with respect to how they say that we're not entitled to go forward because of the Georgia election code. There is no preemption. The Georgia election code does not preempt a constitutional right of my clients. And they've cited no authority to indicate there's been a preemption of anything with respect to that.
It's more of a standing argument than a preemption argument.
Similar, it is, Your Honor, but there's still no authority to say that this court doesn't have authority to address the constitutional violation. You clearly do have that authority.
The authority where there's a concrete and particularized injury.
Yes. And in this case, there is a particularized injury. Based upon the complaint, my client's voting rights have been diluted, been disenfranchised, and have been debased by what we have alleged occurred in the 2020 election, and which we allege is likely to occur in the future if the court does not give us the remedy we are requesting. We have cited in our brief, Your Honor, multiple cases in which courts have addressed through declaratory relief and injunctive relief violations of voting rights, voting dilution. And we suggest to the court that the court has the authority under the injunction to be able to remedy what has occurred in the past, or what will occur in the past, what the policies in the past, and then to address those issues with respect to the relief that we're asking for in the future.
It's interesting that Chief Judge Pryor says in his opinion in the first paragraph, says that we agree with the district court that Wood lacks standing to sue because he fails to allege a particularized injury, period, and because Georgia has already certified its election results and its slate of presidential electors, and so forth.
The relief that he was requesting was moved at that point. Because in essence, what Mr. Wood was arguing was an election contest. He was arguing some type of an election contest type case in which he was not a party. This is not an election contest case. This is a constitutional case.
Well, I understand that's your point of view, and I think that they were characterized a little bit differently. But in any event, is there something else? I don't want to interrupt you.
No, Your Honor. I believe our brief sets forth and again, it is the burden of the respondents to show that under our plea, there is no conceivable way with certainty, we will not be able to prove our case. We will not be able to prove an equal protection violation. And that there will be no remedy that this court can give us with respect to an injunctive or declaratory relief. And I simply assert that under the pleadings that we have made, it is clear that there are problems that occur. It's clear that those problems are likely to occur again, and that those problems result in a denial of equal protection and due process.
Are you aware of any GBI investigation into whether or not counterfeit ballots were introduced into the mix during the tabulation?
I am not, Your Honor.
Are you aware of any report by them?
I am not, Your Honor.
Are you aware of any frustration by them connected with the court's order, which was preserving the evidence in this case?
Absolutely not, Your Honor.
Are you aware of any effort by the State Board of Elections in its investigation to examine this issue?
I am not, Your Honor.
Are you aware of any frustration that has been expressed to you or others, indicating that somehow this court's effort to protect and preserve the absentee ballots with an injunction somehow has hindered their ability to do their work?
Absolutely not, Your Honor.
Does it appear in the record in any way, shape, or form that that's the case?
It does not, Your Honor.
It does not.
It does not.
All right. Is there anything else you'd like to share?
No, Your Honor. I believe everything else is set forth in our response to the motion to dismiss. Thank you.
I'm sorry, I apologize. Did you guys go ahead? Well, if I have anything?
Is there anybody else that has anything that they'd like to say?
Hi, Your Honor. It's going to be quick. He covered a lot of what I was going to. I just want to talk about Lujan for a minute. My understanding of that was it was the complaint, the generalized complaint was people wouldn't be able to go down and look at wildlife. That wasn't centralized because the individuals didn't say they were the ones who were going to do that. Right? In our case, it's not a case that anybody can be brought. There's really two groups. You got a group where their votes have been strengthened because of possible counterfeit ballots. You got a group where the dilution, the vote value has been lessened. In Jacobson, it talks about a comparison. It talks about apportionment. You know, it's the way I see it is the dilution and apportionment are similar issues. And it all, could be a state statute, but also state action. The way you act in the state, you don't have to necessarily have a statute, but state action can often create a violation of equal protection and due process. And I think that's what we're arguing. That we've said in our complaints that there was negligent supervision, these types of things, betting actors, the like. Also, in versus people versus machines, in curling, everybody had to use that machine who wanted to vote first. So when you look at that, then that would arguably be generalized. It wasn't, because in curling they said, well, there is a big group, but they can pinpoint where they have been harmed. And our clients can pinpoint where they've been harmed by the dilution of their vote, the lessening of the vote.
How do you determine whether or not there has been dilution unless you look at the ballots?
I think you have to look at the ballots to determine that, Your Honor. I think we have some evidence in the record saying that people said they observed what they thought were counterfeit ballots.
And neither the State Board of Elections nor the GBI, to your knowledge, has looked at these ballots to determine whether there have been counterfeits introduced into the mix.
My knowledge, that's correct, Your Honor.
I would love to hear from them. I'd like to know.
Well,
Because I think at one point in one of your briefs, Mr. Samuel, you indicated that that they have done something.
they have.
And the question is, what have they done? And you didn't allege that in your brief. So, nor have I heard it from you today. But you know, you don't work for them. You work for these other people.
Yeah, but I went and talked to the people at the state election board. And I didn't talk to the GBI, but the people who were managing the GBI, whatever, called the GBI. The GBI interviewed Ms. Boyles, who's one of the key witnesses in this case.
That's true.
That they interviewed her at length about her claim that she saw a stack of ballots that all appeared to be new and she couldn't do the number. They showed it to her.
They showed her what?
Those ballots.
Oh, they did.
Oh, they most certainly did. And it's all taped. It's all a taped interview. And they showed her the ballots and they said, well, this is, I don't remember the batch number, 245.
I can remember.
Here's batch 245. And it's a very calm, very sedate interview by two GBI agents or GBI, FBI, whatever, law enforcement. And they said, what? Your affidavit says that these ballots are all fake or they all appear to be the same. Can you point out what they're talking about? And she says, I guess I got the wrong batch number. I guess it didn't happen with that batch. Maybe it was some other batch. And all these interviews were being done by the GBI back in, as I remember, early January, something like early January, right after all these allegations were being made. Ms. Boyles testified in the Linwood case. This is not the record of this case. You asked a question, so I'm answering it.
No, it's fine. I appreciate it.
So the GBI was doing this, and then all of a sudden everything got locked down. I'm not with the AG's office. To be honest with you, all I know is they said we couldn't proceed. I don't know.
Why?
Why? Why didn't they do something? I don't know. Let's call the AG and ask them. Let's call the SMB.
Can we shift back to your argument in just a moment? I want to be sure that that Mr. Harding has had a chance to complete his argument.
Yeah, I'm sorry.
That's fine.
That was basically what I wanted when I was.
But your focus is on the harm and the dilution, which I understand.
Yeah.
But it's the concreteness. Which is, I don't think the issue here, but the particularity argument that was raised and addressed by Pryor in a way that was adverse to you in that proceeding back whenever it was. So was it December of 2020 that it was ultimately affirmed by the 11th Circuit? Yes. So what is your position regarding the need for your petitioners to have some sort of particular injury that is different from the rest of the citizens of Georgia, the rest of the citizens of the United States of America?
Well, because I don't think that everyone's vote was actually weak. There was a set of people that their vote was strengthened, but in regard to particularity, I think the particularity means something happened to me.
Right.
I think in that group, they could say, with counterfeit ballots, my vote was diluted. In relation to, in like apportionment, for instance. I mean, there's a huge group of people who could probably bring that claim. But if only one of them brought it, they would still have a particular injury because they were within the group that was in it.
All right, thank you. Please. First of all, we very quickly look at the Crowley. Listen, you know this, that a district court decision is not binding.
It hasn't been affirmed.
Not been affirmed, it's been stayed. Eleventh Circuit stayed Judge Totenberg's case, and it's pending on appeal now. Listen, I'm a fan of Judge Totenberg. I'm a very smart judge. Her order is thoughtful, but it's certainly not, has no precedential value because it's been stayed by the 11th Circuit, and it's currently on appeal now, the entire case.
Let me ask you a different question. And it relates to the issue of staying the case. Would your clients be opposed to staying this case to request from the GBI and to request from the State Board of Elections? It's apparently conducting an investigation until such time as, and then requesting from them an amicus brief be filed so that we can better understand what it is that they're doing, so that we're not stepping on their toes, so that they're not stepping on our toes, so that what we're doing is, if should it come a time where we're crafting a remedy, that everybody knows what everybody's doing.
I would like to consult my clients, but I can tell you, I think the answer to that is going to.
Let's take 5 minutes.
County who voted for Biden, hypothetically, got to vote 5 times. Their vote was tabulated 5 times. But me in Juneau, Alaska, I only got 1 vote for Mr. Trump. And the result was that Georgia electoral votes went for whatever. So, and that's what Judge Pryor said in Glenwood. He said, your argument, clearly would apply not just to the people of Fulton County, not just to the people of Georgia, it would apply to everybody in the country. To some extent, their votes count for less because the people in Fulton County got to vote 5 times for Trump, 5 times for Biden, whereas everybody else only got to get 1. I know Ms. McGowan wants to speak to you.
Well, Ms. McGowan she's not available apparently. Look,
there she is.
There she is, Ms. McGowan. First of all, do the parties object to hearing from Ms. McGowan because they have not intervened? She doesn't represent anybody in particular. Mr. Harding?
We don't object to hear from her, but I would like to clarify. We're under the impression it wasn't the GBI, the Inspector General from the Secretary of State's office. That's just,
okay. And so any objection from your side, Mr. Bunter?
Your Honor, certainly not if the court wishes to hear, although we don't have any way to know what's going to be said or respond or rebut or anything that's going to be said.
Just as a friend of the court, and we'll take it for what it is, and we'll give you an opportunity to ask questions to the extent that you have questions.
Thank you.
All right, Ms. McGowan.
Yes, Your Honor. I'm happy to address the issue of the pending investigation by the Secretary of State's office. And to clarify, the initial investigation is done by the Secretary of State's investigative staff. They make a report then to the state election board, who then makes particular decisions and findings about whether to take any further legal action. So the investigation by the Secretary of State into the complaints related to Fulton counties and their processing of ballots in the November election is still ongoing. I cannot say for certain right now whether any order that has been entered by the court is a fact. I'm happy to find out from my client if they've had any issues or setbacks. I'm not aware of it personally, but I don't want to speculate and say for certain, but I'm happy to report to the court after I've had an opportunity to consult with the Secretary of State's office. We'd certainly be happy to provide a further amicus brief as to what the status of that investigation is. I believe GBI investigators were involved initially at the beginning because there were criminal allegations involved. But for the most part, the Secretary of State's investigative staff have been conducting that investigation. And if you have any further questions about any of that, I'm happy to address them.
All right. So you're here representing whom?
The Secretary of State.
Okay.
I also represent the state election board, but it was the Secretary's office that submitted the amicus brief that we filed in this case.
Well, to the extent that they're asking me to craft some sort of a remedy by way of an injunction, because they claim that there's some redressability here that an injunction can address. I think it is important that we know what, if anything, you are doing. And we don't want to hinder it. And we also want to be sure that we're not duplicating anything. And I don't know if I'm speaking loudly enough. And that is, of course, assuming that there's some way to get that standing. And that's going to be a treacherous and interesting analysis. In any event, I would like to see if there's no objection from the parties that we invite the State Board of Elections to submit an amicus brief. We invite the GBI to submit an amicus brief. And I don't know who represents the GBI. And to the extent that they, you have any contact with them, Ms. McGowan, and you are able to inform them of the court's interest in that. They could choose to do so or not to do so. In any event, we could just allow for perhaps 10 days, 20 days, whatever is a reasonable period of time to receive any information that you think might be relevant to what we're doing, including whether or not there is an injunction that's providing any sort of problem for you. What I mean by that is an order that's preserving evidence, for lack of a better term here, that is concerning to you and to the folks that you are representing and working with. So I'm open and to doing something like that, just staying litigation, staying a decision on the motion to dismiss until after we hear from them, if that is not something that anybody strongly objects to. Have you had a chance to discuss that during the break?
I haven't really talked to my clients from the break, but if I can tell you, then I will urge them that absolutely let's hear what's important to you, it's important to us. It's clearly not irrelevant, so I'll state my maybe I'll get fired between now and the next time you see me, but I believe my clients would say absolutely. If we want to get a report from the GBI, get a report from the Secretary of State's investigators, first of all, verify what I've been saying, which I know to be true, because I sat down with the investigators. There was the GBI, he was there, he listened to them, interviewing Ms. Boyle, so clearly the GBI, not just OIG people. I think it would be great to get more information about the extent of the investigation and what the investigation, what the future holds as far as the investigation.
Well, perhaps we can decrease and allow them to increase, depending upon what it is that they tell us.
We're certainly happy to do.
Any objection?
I didn't want to talk over council.
Right.
We don't object to anything that the court believes the court needs to receive in order to be able to make a proper decision. So if the court feels that this is something the court needs to do, we don't object to anything that Your Honor would like to do to be able to make the right decision.
I'd like to hear from them. And so, Ms. McGowan, that's a formal request from you, or to you, I should say. And we'll just stay the case for maybe 15 days. Is that enough time?
If we could have
Receive an
20
amicus
days,
brief
Your
from
Honor,
you?
that would. If we could have 20 days, I would appreciate that, Your Honor. Especially,
20 days?
Yes, our office represents a GBI, and I can certainly look into a report on their involvement in this matter, and we'll provide any update with respect to the GBI, and then also where the Secretary of State's office is with their investigation.
Because it is important to me that we know whether or not counterfeit ballots have been introduced into the mix. That is important to me.
Certainly, Your
It's
Honor.
important to my
I appreciate
decision.
that. Mhm. Absolutely.
And it's something that can be known.
Yes, it is something that the Secretary of State's office has spent many, many months looking into, and to make sure that they get the investigation done correctly and thoroughly.
Has the Secretary of State's office looked into whether or not there have been counterfeit ballots? Have they looked at the ballots themselves?
My understanding is that they looked at particular batches of ballots that they received specific complaints about. And I believe that those batches of ballots are included in the petitioner's claims, but they received specific complaints about particular batches of ballots. They were given the numbers of those batches. They looked at particular ballots and determined that they did not appear to look counterfeit.
Okay, we're going to stay the case for 15 days, and then we'll make a decision on the motion to dismiss.
She asked for 20 days.
20 days, my mistake.
There's one mic, there's like Steve Rosenberg, I'm half Fulton County. I don't have an infection, obviously, for a short period.
Thank you.
For that purpose. There are some other outstanding issues with respect to sort of security during that time. I know the clerk and the sheriff have filed some motions with respect to that.
I read that motion by the clerk. It is very thorough, complete. I'll hear from the other side regarding that. Do you wish to speak to it?
Yes, Ms. Martinez is the fully speaking about.
Good morning, Your Honor. Dominique Martinez here for the Kathleen Tina Robinson, Superior Court Clerk of Fulton County, and here on behalf of Sheriff Ballot, Sheriff of Fulton County. With respect to the motion to modify the security arrangement, Your Honor, I think the motion kind of is pretty simple. It outlines what the issues were, and just to recall your memory, Your Honor, the security arrangement that is discussed in that motion, which entails the physical presence of the deputy from the sheriff's office 24 hours a day, 7 days a week, did not come about because there was a security concern. What led to the phone call with the court in May that resulted in this agreement was really the staff with the Registration and Elections Department had concerns about there were people surveilling them. And those people were hired by the petitioners. And during a phone call as a result of that concern, the sheriff took the extraordinary step to alleviate whatever caused them to want to surveil the DRE staff and said we'll provide 24 hours a day, 7 days a week security, physical security of the deputy. That's never been, has never occurred before, to our knowledge. The sheriff had testified, his deputy has testified he's unaware that ever happened. And it's really unnecessary. It's a waste of taxpayer dollars right now. It was sort of a moment to appease the petitioners. And it's not necessary ongoing right now. The sheriff has done a physical or security assessment and will agree to provide such security if it's necessary. But at this point in time, the sheriff would like authority to modify that arrangement so that he can make the necessary judgment calls and enter in whatever security arrangement is needed, whether it's more or less than what was agreed.
I think you've also indicated that to the extent that they want to have sheriff's deputies on site 24/7, as long as they're willing to pay for it, then you're willing to do it.
Yes, Your Honor, because that is a large part of the issue, is that the sheriff of Fulton County is expending taxpayer dollars to pay for a physical presence of a deputy there 24 hours a day, costing him overtime expenses that he did not budget for.
And of course, the sheriff's deputies would be responsible to him, even if they're paid for by them.
Correct.
Okay. Is there anything else?
No, Your Honor, unless you have any questions for me about that.
Now, we received that motion, I believe, just a few days ago, and not had a chance to fully analyze the motion. We would like an opportunity to be able to look at it in more detail and have discussions with counsel, discussions with the private. They're actually not private, but it's our security, people that are there outside, on the street. To have that discussion, we haven't had a chance to do that. We asked the court for time to be able to address that question, see if we can work out some kind of agreement. We may be able to work out an agreement with the sheriff and with the court. We haven't had time to really do that. We just got the motion in 2 days ago.
Well, I'm inclined to agree with the clerk and with the sheriff that this is something that you should pay for if you want, and to otherwise leave to the discretion of the sheriff and the clerk how it is that they protect and preserve the ballots at the Eagle Street warehouse. And so I'll give you the same 20 days that you've given Ms. McGowan to respond to the motion. But frankly think that you should be responsible for the cost of providing those sheriff's deputies from this moment going forward, if that's something that you feel is necessary. Are you willing to incur that cost?
Yeah, we have not had I've not had an opportunity to discuss that with our lead counsel, Mr. Keeley, or with our clients. We're not at this moment going forward, and we don't even know what, particularly in their motion, they are complaining, or how much it was going to cost, or what it was going to cost, or what the hourly rate is, or anything else.
Mm-hmm.
I'd like an opportunity to be able to review their motion, respond, and then confer with my clients and confer with them.
What's your response, Ms. Martinez?
Yes, Your Honor. The sheriff can obviously provide an estimate if that's necessary. We do report that petitioners think that is a necessary expense or a necessary security measure that no one else has ever brought to the attention of the court or the sheriff, then the petitioner should bear that expense. And if it requires the sheriff to advise them of how much it's going to cost, the sheriff can do that promptly, so that the petitioners can either agree or not. But that is likely the only arrangement that the sheriff can agree to continue with the current security arrangement.
Because the sheriff is representing to the court that the ballots are otherwise secure.
Correct, Your Honor. As is the clerk. There's no indication
As is the clerk.
to them that they're not.
Okay.
And just to be clear, Your Honor, it was an agreement. There wasn't a court order requiring it, but out of respect for the fact that the sheriff had agreed to that to the court is the reason why the sheriff and the clerk moved to request the court's permission and approval to modify without doing it on their own, even though there wasn't technically a court order mandate.
When was this motion filed?
It was filed on September 14th, 2020.
And there hasn't been time to discuss whether or not they can or would be willing to pay for it?
We have not had that discussion yet. Your Honor, Mr. Keeley, as you know, is in a jury trial right now. We've not had an opportunity to discuss that with our security group, or even discuss it with the clerk to find out, what exactly is their budget, what they want us to pay, how many people. We don't know that.
If you want sheriff's deputies to be at the site, based on what I'm hearing from them, you're going to have to pay for it, starting now. Anything else?
No, Your Honor, not from the clerk and the sheriff.
Yeah, from Fulton County, just briefly, during that 20-day stay that we are now in, can we file matters with the clerk? We'd like to respond to some of the petitioner's most recent filings, trying to dismiss everybody. The court asked an important question during its questioning, which was, what exactly do you want? And the follow-up question to that is, how in the world are you going to get it from just two board members? And they can't. And that sort of revealed where we are in this case. They're not trying to, basically litigate their rights. They're just trying to get at the ballots. And the lawsuits don't do that. You've got to actually, basically, prosecute your client's claims. And they're not trying to do that. And their most recent filing has shown that. They've stated it's not an election contest. I think I know the court is concerned about serious claims that they're raised, but they're not really that concerned with them. They just want to win something in the court of opinion. That's why they've been going after these ballots. I think the court on its own motion could dismiss this case. I think this court should, on its own motion, remand the case to Fulton County because it's not an election contest. We heard counsel say that this morning. All the plaintiffs have filed something stating that's the case. There's case law out there that suggests that matters that get transferred to an outside court judge. It's a very specific statutory scheme, and when those things don't exist, the court lacks jurisdiction. So I appreciate everything that you're saying.
I'm not aware of any a case that's
and that's why I was going to ask if during the stay, if the court's going to accept the court will accept filings in the matter, because I'd like to brief that issue.
Staying the case means the case is stayed. We'll hear from the amicus, and then we'll hear from you at the conclusion of the 20 days. Is there anything else?
Would the court consider? I know the court likes to hear argument, which I appreciate.
Yeah.
Would the court consider setting a date certain now or sometime after that? I'll file it on May 20 And then we can have a hearing date set at some point later.
Sure, but let's get out our calendars. Ask my secretary to step in and we'll go from there.
Thank you, Judge.
Is there anything else that we must hear today?
Your Honor, this is Ms. McGowan. If I could just clarify something with the court with respect to what the court is asking for in terms of further amicus brief. I just wanted to clarify that this is an ongoing law enforcement investigation that the Secretary of State's office is conducting. Typically, when they've completed the investigation, they will do a formal report, present the results of that investigation to the state election board, and then they vote to make a determination as to what further legal action to take, because it is the state election board that has enforcement authority over enforcing the elections code. So typically, the ongoing investigation remains private until those results are presented to the state election board. So while I can provide the court with a status update as to where they are, what their expected time frame is as to when the report will be concluded, I can do that.
And remedies that you have available to you under the code.
Okay, I can do that as well. It's just getting into specific findings. I'm not sure. I'd have to consult with my client. I'm not sure what we can reveal prior to presenting that case to the elections board. If it's something that the court wanted to discuss in camera, maybe we could look into that. But as far as specific findings, until those results become public, it's not something that we put in public pleadings.
Okay, that's reasonable. Thank you. Anything else?
No, sir.
No, Your Honor.
Oh, Your Honor.
All right, well, listen, thank you for your time and for your argument. And that will conclude this matter for today. We're adjourned.